Hello, I'm Katie Holt and I'm an employment solicitor at Irwin Mitchell. Today, I'll be talking you through equality and diversity, and we'll also touch on safeguarding. If you have any questions on anything that we cover today, please do get in touch. So before we look at religion and belief, what is equality, diversity and inclusion, and why does it matter? As you will see from the slide, it sets out the definitions. So equality means ensuring every individual has an equal opportunity, regardless of where, what or whom they were born, what they believe, or whether they have a disability. Diversity means celebrating and respecting our differences, so treating everyone with respect, engaging with different viewpoints, and inclusion means working together regardless of background, identity or circumstance, feeling included, valued, accepted and supported to succeed at work. So why does equality, diversity and inclusion matter? Well, first and foremost, it's the law. Then we'll come on to what that entails a bit later on. The UK is a multicultural, multi-abled and neurodiverse country. To reflect this, UK legislation sets minimum standards on employee-employee relationships involving diversity. This is to ensure equal opportunities for all in the workplace, and this is reflected in the Equality Act 2010. Failure to follow this legislation can lead to discrimination cases. Most critically, employees and workers can be held personally liable for discrimination claims brought by a victim in an employment tribunal and can face financial penalties, and employers can be held vicariously liable for actions of its staff. There are no minimum service periods to pursue a discrimination claim. But it's not just the law. There could also be reputational damage which could impact on future recruitment. Having a workplace that encourages equality will help employees be more successful, happy and motivated, which allows employers to keep morale and profits high. Employers can promote equality opportunities in the workplace through internal policies which support employees properly. Promoting and respecting employees' rights ensures that everyone feels that they are valued, belong and have a voice. When we respect each other and feel valued, it makes us a great place to work, people want to stay and great people want to join us. So as you will see from the slide, here are some of the groups that, through promoting equality, diversity and inclusion, we can ensure have an equal opportunity to flourish in the workplace, but this is not an exhaustive list. The Equality Act 2010 seeks to provide equality in the workplace, as previously referred to. It sets out 9 protected characteristics and protects workers who hold these protected characteristics from being treated any less favourably or discriminated against in the workplace. So on the screen, you'll see 12 characteristics. 3 of these are not protected characteristics in the Equality Act. Take a moment to look through and pause the recording to see if you can spot the 3 protected characteristics which are not protected. The characteristics which are not protected, which are shown on the screen, are hair colour, cohabiting couples and weight. The rest are all protected under the Equality Act. You can see how the groups we talked about earlier from an inclusion point of view are potentially covered by these protected characteristics. For example, neurodiversity may match disability. Those with childcare responsibilities, who statistically more likely to be women, are protected due to their sex. So you can see how inclusion, not discriminating, equals the law. So who can bring a discrimination claim? As you will see from the screen, there's a number of people that can bring a discrimination claim. That is employees, contract workers, agency workers, and prospective workers. Volunteers are not usually covered. In order to be covered by equality legislation, a volunteer will need to be in employment for the purpose of the Equality Act. The definition of employment in the Equality Act is broader than in other employment legislation and includes not only a contract of employment, but also a contract person to do the work. And the definition, therefore, clearly does not cover voluntary workers without a contract. Volunteers may, however, be held to be a worker or an employee, for example, if they are paid over and above the value of their reasonably incurred expenses. So please exercise caution here if you do have volunteers within the organisation. There are different types of discrimination. One type is direct discrimination. This is when a person A treats another person B less favourably than A would treat others, and A does so because of a protected characteristic. Direct discrimination also covers discrimination by way of perception. So if B did not have the particular protected characteristic, but A thought they did, and treated them less favourably because of this, this would still amount to direct discrimination. Direct discrimination claims brought in relation to the effect of a protected characteristic possessed by someone other than B, as sometimes called associative discrimination claims, i.e. the unfavourable treatment is done because of B's association with a person who possesses that characteristic. Here is an example of discrimination. So, my boss suggests I apply for an internal promotion. I didn't get the job. I think it could be because they found out I'm trying for a baby and they don't want me to get the role and then be on maternity leave. This is less favourable treatment because of a protected characteristic, which is sex. It's unlawful to treat a worker any less favourably than you would do another worker who did not possess that protected characteristic. This would amount to direct sex discrimination under the Equality Act. Other types of discrimination include indirect discrimination and victimisation. Indirect discrimination is where a provision, criterion or practice, known as a PCP, but you may want to think of it as a rule, policy or practice, that is applied more widely but has a disproportionate adverse effect on particular groups of people, and furthermore, this rule, policy or practice cannot be objectively justified. There is a potential defence called the justification defence if an employer can show that practice or policy is a proportionate means of achieving a legitimate aim. Victimisation is where a person A is subjected to a detriment by another B because A performed a protected act or because B believes that A performed or will in the future perform a protected act. Protected acts include bringing a claim under the Equality Act and making an allegation that has been a breach of the Equality Act. So you should treat people as you treat others, indiscriminatively, without difference according to their protected characteristic, background or traits. So harassment is the unwanted conduct that has a purpose or effect of violating a person's dignity, creating an intimidating, hostile, degrading, humiliating, offensive environment for that person because of a protected characteristic. And as you'll see, that definition is on the slide. So this is an example of discrimination. Gary is teased by his colleagues for being gay, laughing at his clothing and the way he talks. Gary is not gay and doesn't find the jokes funny. His colleagues tell him to lighten up and it's only a joke. Gary raises a grievance to his manager, who also likes to joke about it. Gary's manager tells him to stop being so sensitive and excludes Gary from the after-work drinks he arranges with the team. The jokes made about Gary are an example of harassment based on a protected characteristic. Here it's sexual orientation, Gary's perceived sexuality. It doesn't matter that Gary isn't gay himself, he can still bring a discrimination claim despite not holding the characteristic. It also doesn't matter that his colleagues didn't mean to cause offence. The law doesn't look just at what was intended by the words said, but also the effect they had on the victim. Here, the banter is clearly unwanted and creating a hostile and humiliating environment for Gary. I didn't mean to cause an offence is not a defence. Furthermore, workers are protected from being treated badly as a result of raising discrimination concerns or supporting others in doing so. This is called victimisation. Here, excluding Gary from the work drinks because he raised a complaint of discrimination could amount to victimisation. Continue a theme of workplace banter. The middle quote you'll see on the screen is from the real-life case of Reed against Stedman. Miss Stedman was employed as a secretary for a year, during which time the marketing manager's behaviour towards her was, according to the tribunal, bullying and pervaded with sexual innuendo. This was one of the comments made to her. The tribunal held that it amounted to harassment on the grounds of sex. Again, it was no defence that the comments were meant as a joke or not intended to cause offence. In relation to the half-dead Dave comment on the left, in Robson against Clark's Mechanical Limited, the claimant received £13,000 compensation for the injury to his feelings at the ageist slur. In relation to the bold comment on the right, the tribunal found that a male factory worker had been called a bold expletive, and this amounted to discrimination on the grounds of his sex. The key point is that making jokes about someone else's appearance can amount to harassment, even if you do not intend to cause offence. So be mindful. What might not be offensive to you could be offensive to others. So please do call out or encourage people to call out inappropriate banter. Don't join in and report it to the correct channels, such as your line manager. Let's talk about religion and belief. So as you'll see from the slide, there's some definitions of religion and belief in an employment context. As we know, religion and belief is one of the 9 protected characteristics in the Equality Act 2010. As such, individuals are protected from discrimination in the workplace because of those beliefs. But what exactly is a belief and what is capable of protection? Religion means any religion and also includes a lack of religion. Belief means any religious or philosophical belief and also includes a lack of belief. Beliefs that are shocking or offend others are still capable of being protected. In order to be protected, the belief in question has to pass a number of tests, including that it must be worthy of respect in a democratic society, the concern a weighty and substantial aspect of human life and behaviour, and attain a certain level of seriousness, cohesion and importance. On this slide are some examples of beliefs that have been held to be protected under the Equality Act by the courts and tribunal. This gives you an idea of the types of beliefs that colleagues may hold in your organisation which would be protected from the discrimination in law. So I'm just going to talk about just one example on the slides. Mankind in Granger plc against Nicholson, the Employee Appeal Tribunal held that an employee's belief that mankind is heading towards catastrophic climate change and that human beings all come under a moral duty to lead a life that could help to mitigate or avoid this catastrophe was capable of constituting a philosophical belief. Lying is always wrong. In Hawkins against Universal Utilities Limited, the claimant was dismissed from his job at a telesales company for failing to meet sales targets. He gave evidence that he had been told to lie to potential customers in order to achieve sales and argued that this amounted to indirect discrimination because his Christian beliefs would not permit him to lie. The Employment Tribunal accepted that a belief that it is wrong to lie under any circumstances amounts to philosophical belief. Employees have an absolute and unqualified right to hold any beliefs or opinions, but do not have the same unqualified right to manifest those beliefs in their place of work. Courts have recognised that someone manifesting their belief may have an adverse impact on others. Employers can impose restrictions on what staff can say and do at work, but must be able to justify this. For example, for the purpose of promoting equality or diversity, or to protect their corporate image. There are a number of beliefs related to sex and gender which are potentially capable of protection. This is a tricky area and one in which we are seeing more claims arise. It's important that you're aware of and have an understanding of these different beliefs. And I've set them out on the slide for you. So an example of beliefs about sex and gender. So M, a Christian doctor, told his employer that he would not use the preferred pronouns of transgender service users in compliance with his employer's policy, as this conflicted with his personal beliefs. So in this case example, we have an employee who, due to his own religious beliefs, holds gender critical beliefs, i.e. believes sex cannot be changed. This conflicts with the employer's policy instruction for him to use transgender service users' pronouns as part of a respectful equal opportunities services. So, could his employer force him to comply with the organisation's rules? This example is based on a real-life case. In this case, the answer was yes. The employer could evidence adequate business justification to instruct M to use the personal pronouns, even if it was in conflict with his own personal beliefs. After M expressed his beliefs to his employer, they listened to these and considered whether or not they could accommodate them. They considered alternatives. However, they could not offer him a non-customer facing role because this required at least 12 months experience. It was also not possible to ensure that M only worked with non-transgender service users because they might not present as transgender until they attend a face-to-face assessment with the doctor. There were no other alternatives. The employer's justification for requiring him to use the pronouns was to promote equal opportunities and ensure transgender service users were treated with respect and in accordance with their rights under the Equality Act. The tribunal held that this was adequate justification. So the key points. Everyone has the right to hold their own beliefs. Don't impose your own opinions. Just because you don't agree with a view doesn't mean that it shouldn't be accepted or respected in the workplace. And support your organisation in the celebration of diversity and promote inclusion. Foster an environment of tolerance. So next we'll move on to talk about disability in the workplace. So I've set out on the slide the definition of disability under the Equality Act. So an employee who meets the test for disability has a number of additional employment rights, including the right not to be discriminated against on the grounds of their disability, and for their employer to consider and make reasonable adjustments to ensure they are not placed at any substantial disadvantage in the workplace when compared with their able-bodied colleagues. So looking at the definition on the slide, a disability is any mental or physical impairment which has a substantial adverse effect on an employee's ability to carry out day-to-day activities and which is long-term. Note that the definition does not look solely at the employee's ability to carry out their role. It looks at their ability to carry out day-to-day tasks, such as walking up the stairs, personal care, reading. Ultimately, it will be up to an employment tribunal to determine if an employee meets the test. However, your legal advisors can give you a steer. Often it is necessary to refer an employee to an occupational health provider or their GP to give an opinion on whether or not they're likely to meet the test for disability. The test for disability is a fairly low threshold and can include conditions that we might not usually term as disabled under the ordinary non-legal sense of the word. Be careful not to judge or use your own opinions, and be careful of hidden disabilities. So here we can see some examples of hidden disabilities. A colleague doesn't necessarily have to tell you or their employer that they are disabled to be protected under the Equality Act. And as you'll see from the slide, I've set out some examples of conditions which may be hidden. Disabled employees are valuable to the workforce. With reasonable adjustments, support and understanding, many can thrive. The purpose of this slide is to remind you to be aware of disabilities, both hidden and not hidden, and of the protection afforded to these employees. Act sensitively and mindfully, and raise any concerns you may have internally. What is your role and responsibility for equality and diversity? When we deal with discrimination complaints arising in the workplace, one of the things we often hear from staff members who have been accused of such conduct is that they hadn't intended to be offensive, or that they weren't consciously aware that they were excluding any particular person or group. The cause, focus and level of these views vary from person to person. However, our daily situations are influenced by unconscious bias whenever we meet or make assessments of others. It's done without us thinking or even realising we are doing it. Identifying these biases can be challenging and to some extent uncomfortable. So how does it affect the workplace? These biases can lead to a less diverse workforce, with colleagues overlooking more talented individuals for others who share their own views or characteristics. We've seen earlier in this webinar what the protected characteristics are and how less favourable treatment can amount to discrimination in the workplace. This treatment can also lead to feelings of isolation, and comments around preconceptions, even if no offence was intended, can indeed cause great offence to somebody and amount to discrimination. In turn, this can have huge negative impacts upon our working relationships, team atmosphere, and in some cases can result in individuals opting to leave a role. So an example. About a year ago, Joe became a proud parent. Joe was on parental leave for 9 months and is now back at work. Whilst reading those 2 sentences, what gender did you associate with Joe? Due to the fact that more women take parental leave compared to men, many of us spontaneously thought of Joe as a woman. But Joe could just as easily be a man. This is a potential example of unconscious bias in action. So what can we do to stop unconscious bias? Every one of us has a responsibility to work on developing ourselves and analysing our own biases that may be at play in the workplace, be it through education, increased awareness, or just stopping to think more about decision making. So stop, think, be aware. So let's talk about equality and diversity policies. So I suggest that you first look at any equality or diversity policy that may be in place within the organisation. This should be your first port of call if you witness any potential discrimination in the workplace, or if you're an employee and you receive a complaint. So have a think about the following questions. Is this a policy you're familiar with? Do you know where you can easily access it? Are you comfortable with what steps to take if you consider that there has been a breach of the policy? And what are the possible consequences of a breach of the policy? If you are an employer and do not have this policy in place, we suggest that you do put one in place within the organisation, and we can support with that if needed. Please do contact me if you need any assistance. The employer may be able to avoid being vicariously liable if it can prove that it took such steps as were reasonably practicable to prevent the employee from doing the act complained of, for which the employee might otherwise be liable. This will usually involve the employer demonstrating that it's implemented a rigorous equal opportunities policy and trained all employees to adhere to it, and has taken a robust approach to any evidence of discrimination in the workplace. So taking steps to deal effectively with complaints, including taking appropriate disciplinary action. So what are the consequences if you do get it wrong? As set out on the slide, these are the main heads of claim. A tribunal claim can be brought during employment, before or after. An award of compensation for losses of earnings and injury to feelings to a person against whom a discriminatory act has been committed can be awarded. Compensation in serious harassment cases can be substantial, particularly if the harassment has led to the victim suffering psychological damage and trauma. And it should be noted there's no cap on the amount that the tribunal can award as an injury to feelings, unlike in unfair dismissal cases. So who is responsible? We all have a part to play in promoting equality and diversity. So an employee who commits an act of discrimination may be personally liable along with the employer. Special responsibility falls to those who deal with recruitment, arrange training and so on. And failing to take action may be an act of discrimination itself. So some top tips. Celebrate and support diversity and inclusion within the organisation. Know your policies. Be mindful of signs of hidden disabilities and be open to explore adjustments that can be made. So let's touch on safeguarding. Safeguarding is about duty of care. It is about providing wellbeing related advice and guidance, or intervening on behalf of a child or vulnerable adult if there is either a suspicion or disclosure that suggests an individual may be at risk of either physical, emotional or sexual harm. It's employees' duty to protect the health, safety and welfare of their employees and other people who might be affected by their work activities. Employees must do whatever is reasonably practicable to achieve this. If your organisation works with children or vulnerable adults, it's vitally important to implement and maintain effective safeguarding procedures in the workplace. It's a good idea for organisations to review their safeguarding procedures regularly to ensure the safety of clients, customers and staff. So ways you can improve safeguarding procedures in the workplace. So review and implement a safeguarding policy. Make sure you are familiar with the safeguarding policy in place. Carry out safeguarding training with the organisation. If your organisation recruits volunteers, make sure they receive the same safeguarding training as provided to employees if they're working for your organisation, even if it's only for a short time. It's vital they understand the importance of safeguarding and adhere to the organisation's procedures. Remind staff what to do if they have a safeguarding concern and make clients, customers aware of the safeguarding procedures in place. As I've said earlier in the webinar, if you do have any questions, please do get in touch with me directly and these can be addressed at the Q&A session. If you want the details of when that session will be, please do contact me. It's yet to be arranged, but I can then send you the details once that is in the diary. Please note this video content does not constitute legal advice and is just of a general nature. Accordingly, viewers should not seek to rely on the content without taking specific legal advice in relation to their circumstances.